The Colorado Civil Rights Division enforces the Colorado Anti-Discrimination Act, otherwise known as CADA. In this video, we will explore the three areas that CADA enforces and the protected classes that are protected against discrimination in each of the three areas. These three areas include employment, housing, and places of public accommodation. Employers in Colorado are prohibited from discriminating against employees based on their protected class. The CCRD investigates allegations of employment discrimination. Additionally, employers have a duty to provide reasonable accommodations that may be necessary because of an employee's or applicant's disability and/or because of an employee's or applicant's pregnancy, childbirth, or a condition related to pregnancy or childbirth. Fair housing laws were enacted to ensure everyone has equal access to the housing of their choice. Fair housing laws apply to housing providers or landlords, but also include real estate brokers, mortgage lenders, homeowner associations, and others. Places of public accommodation are facilities open to and that serve the public, such as restaurants, hotels, shops, public transit, and medical facilities. All persons are entitled to the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of any place of public accommodation without discrimination. Persons who have engaged in protected activity, such as making a complaint of discrimination or requesting a reasonable accommodation, are protected from retaliation for doing so in all three areas of CADA. A protected class refers to groups of people who are legally protected from being discriminated against by laws, practices, and/or policies due to a shared characteristic, such as, for example, race, gender, age, disability, or sexual orientation. These groups are protected by both U.S. federal and state laws. Various state laws, including the Colorado Anti-Discrimination Act, include additional protected classes that federal laws may not include. We will explore these areas, starting with discrimination in employment. In the area of employment discrimination, CADA states that employers in Colorado are prohibited from discriminating against employees, including job applicants, based on their protected class. The protected classes in employment discrimination include disability, defined as a mental or physical impairment which substantially limits a major life activity. Race, including hair texture, hair type, hair length, or a protective hairstyle commonly or historically associated with race, such as braids, locks, twists, tight coils or curls, cornrows, bantu knots, afros, and head wraps. Color discrimination, based on the person's skin tone and can occur within the same racial groups. Religion, creed, treating someone unfairly or differently based on their religious beliefs or practices or their lack of religious beliefs. Sex, gender. Sexual orientation, treating someone unfairly or engaging in harassment based on their actual or perceived sexual orientation. Gender identity, treating someone unfairly or differently because of their gender identity, which is a person's internal sense of being male, female, or another gender. Gender expression, treating someone unfairly or unequally because of how they outwardly present their gender. Age, 40 and older, occurs when someone is treated unfairly or less favorably because of their age, specifically those 40 years of age and older. National origin, Ancestry. When someone is treated unfairly or unequally based on their or their ancestors, country of origin, ethnicity, accent, or other characteristics associated with a specific national origin group. Marital status. Defined as relationship or spousal status of an individual, including but not limited to being single, cohabitating, engaged, widowed, married, in a civil union, legally separated, or has had or is in the process of having a marriage or civil union dissolved or declared invalid. Marriage to a coworker occurs when an employer treats an employee differently based on their marital status. And pregnancy, which occurs when an employer or other entity treats a woman unfavorably because of her pregnancy, childbirth, or related medical conditions. Examples of prohibited employment practices based on protected classes as listed on the CCRD website may include refusal to hire based on a protected class, such as race, color, or national origin. To discharge or fire an employee. To refuse to promote an employee. To demote an employee. To harass an employee during the course of employment. To discriminate in matters of compensation, including matters covered by the Wage Transparency Act. To discriminate in the terms, conditions, or privileges of employment. And to retaliate against someone who has engaged in protected activity. Fair housing laws apply to providers, including landlords, but also include real estate brokers, mortgage lenders, homeowner associations, and others. The protected classes in housing discrimination include similar protected classes as defined in employment, such as disability, race, color, religion, creed, sex, sexual orientation, gender identity, gender expression, national origin, ancestry, and marital status. Protected classes specific to housing discrimination include familial status. Refers to children under the age of 18 in the household and includes individuals who are pregnant or in the process of obtaining legal custody or parental responsibilities of someone under the age of 18. Source of income. Defined as when a landlord or property owner refuses to rent to a qualified applicant based on their source of their lawful income. And veteran or military status. Defined as when someone is refused housing based on their status as a veteran or member of the military. Examples of prohibited practices in fair housing may include refusal to rent or sell or make housing unavailable, applying unequal terms or conditions of sale or rental, refusal to allow reasonable accommodations and or modifications necessary to accommodate a disability, redlining. The discriminatory practice of denying services, especially financial services like loans and insurance, to residents of specific neighborhoods based on their race or ethnicity. Steering. The practice of guiding homebuyers or renters towards or away from certain neighborhoods based on their race, religion, or other protected characteristics. Intimidation, threatening, coercion, or harassment. Advertising with a discriminatory preference or limitation based on protected class. Misrepresenting availability. And retaliation against a person engaging in a protected activity, for example, complaining of discrimination or requesting a reasonable accommodation. The protected classes in places of public accommodation include disability, race, color, creed, sex, sexual orientation, gender identity, gender expression, national origin, ancestry, and marital status. It would be a discriminatory action for a place of public accommodation, directly or indirectly, to refuse, withhold from, or deny to an individual or group the full and equal enjoyment of the goods, services, facilities, privileges, advantages of the public accommodation based on that person or group's protected class. Places of public accommodation are also prohibited from publishing, circulating, issuing, displaying, posting, or mailing any discriminatory advertisement. When filing an initial intake inquiry, CCRD must make sure the complaint is within its jurisdiction. Is the employer covered under the Colorado Anti-Discrimination Act? Is the entity an actual place of public accommodation? These are examples of jurisdictional requirements that the division will review from an intake inquiry. In addition, the division will assess whether the allegations clearly state that the alleged harassment or discrimination is based on a protected class. There are also filing deadlines to consider. Filing deadlines differ depending on the area of CAUDA the complaint inquiry is being filed under. Employment filing deadlines are within 300 days of the alleged act of discrimination, harassment, or retaliation. Housing filing deadlines are within 1 year of the alleged adverse action. And in places of public accommodation, the filing deadline is within 60 days of the alleged discrimination. This means if a formal charge of discrimination is not signed and filed within that time frame, CCRD cannot file the complaint. Please keep in mind that the date of filing is the date the signed charge is received by CCRD. After an intake specialist reviews the intake inquiry, they will contact the potential complainant for an intake interview. This interview will be used to ensure the division has jurisdiction over the case and will also gather information to draft a charge of discrimination. The intake specialist will forward the draft of the charge to the potential complainant for review and signature. This is the date the complaint is officially filed and the investigation process begins. For more information on our complaint process, please visit our website and click on the complaint process. We hope this video helps to explain the various protected classes covered under the Colorado Anti-Discrimination Act and how they are applied throughout our 3 areas of enforcement: employment, housing, and places of public accommodation. For additional information, you can visit our website at ccrd.colorado.gov. You can call us at 303-894-2997 or email us at dora_ccrd@state.co.us.